Supreme Court justices returned to the bench Monday for a jam-packed term filled with issues ranging from abortion and guns to immigration and gay rights. On Tuesday, justices will consider whether a federal employment law barring discrimination based on sex also protects LGBT employees. Natalie Brand spoke to a plaintiff in one of those cases.
I didn't ask for any of this.
Gerald Bostock's legal battle started 6 years ago. On Tuesday, he takes his fight to the nation's highest court. Bostock was a child welfare coordinator for Clayton County, Georgia. He says he lost the dream job that he held for more than 10 years shortly after he joined a gay softball league.
I was fired for being gay. I lost my source of income. I even lost my medical insurance at a time that I was battling prostate cancer.
In a statement to CBS, an attorney for Clayton County says Mr. Bostock's sexual orientation had nothing to do with his termination, saying he was let go after a financial audit.
For Clayton County to suggest and allege that I did anything wrong is absolutely offensive and hurtful.
Supreme Court justices will hear Bostock's case along with two others. One involves a skydiving instructor in New York, and the other a transgender woman who was fired from a Michigan funeral home. Ultimately, justices will weigh in on whether Title VII of the 1964 Civil Rights Act extends workplace protections to members of the LGBTQ community.
Title VII has been understood for more than half a century as protecting women from being disfavored compared to men because of their sex and vice versa. It doesn't say anything about any other classifications.
John Bursch of the Alliance Defending Freedom will be arguing Tuesday on behalf of one of the business owners. He says it's up to Congress to specify or redefine the law. More than 20 states have their own laws barring discrimination based on sexual orientation, but Georgia is not one of them.
I should not have to move because of who I am, how I identify, and who I love.
Bostock says he's now fighting for the many others who may be in similar situations. Natalie Brand, CBS News, the Supreme Court.
For more on this, let's bring in Ilya Shapiro. He's the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute, and he joins us now from Falls Church, Virginia. Ilya, thank you so much for being with us.
Good to be on.
So the High Court is expected to hear 3 separate cases on the issue. How can we expect the plaintiffs to argue in favor of Title VII providing protections to the LGBT community?
Well, I think this case is going to be a lot closer than what both sides are making out. This is neither about whether the 1964 Congress intended to protect sexual orientation or gender identity, nor is it about constitutional rights or whether we should treat everyone equally as a general principle. It's about a very narrow statute. And the argument is that on the basis of sex necessarily includes sexual stereotypes, gender identity, sexual orientation. A man can't be fired for dressing like a woman. A man can't be fired for being attracted to men, much like a woman can't be fired for being attracted to men or women. The argument on the other side, that the defenders of those that argue that the law does not currently have those protections, is that on the basis of sex, and that term sex as understood in the 60s when it was first enacted, and since then with several amendments, means biological sex. It doesn't mean being attracted to another gender or orientation, doesn't mean some of these other things. And indeed, Congress several times has tried and failed to add explicit protections for both sexual orientation and gender identity. Again, this is not like the gay marriage cases. This is not what about the Constitution requires. This is about the federal statute and employment discrimination law. If the court rules against the gay and transgender individuals in this case, Congress can always pass a law adding those protections.
So Justice Kennedy, who was seen as a champion of LGBT rights, retired last year. He was replaced by his former clerk, Brett Kavanaugh. What kind of an impact can we expect that to have, if any at all?
Well, it's unclear because all of the cases in which Justice Kennedy was ruling, and generally in favor of the LGBT community, were constitutional. As I said, the way that statutes work are different, and the court generally is more hesitant to rewrite or expand statutes because, of course, Congress can change that, whereas with the Constitution, it takes a constitutional amendment, which is a higher bar. But indeed, all eyes will be on Brett Kavanaugh to see, how he applies statutory interpretation. Neil Gorsuch as well has a pretty libertarian streak, as we've seen the last couple of years. What does that mean? Again, in the statutory interpretation context, I think it means something different than it does for the Constitution.
Well, what kind of broader implications could the High Court's decision have for the LGBT community?
Well, about half the states have their own protections for sexual orientation or gender identity. So for people in those states, this doesn't change their legal status, unless you're working for the federal government, I suppose, in those states. But even there, the Department of Justice, the Trump Department of Justice, this year extended protections to gender identity and sexual orientation. So it just depends on what type of job people are working and where they're living. On the other side of the coin, if the court reads in these protections, then there could be some uncertainty about what kind of protections there are for religious organizations, for women's sports, other issues where this is the cutting edge of the law. We really haven't fully developed it.
I want to turn to another issue. On Friday, the justices announced they will hear a challenge to a Louisiana law that critics say would leave the state with only one doctor who can provide abortions. Why is this case significant?
Well, this is the first case that the court has taken up since, as we were discussing, Brett Kavanaugh replaced Anthony Kennedy. And Kennedy was also the deciding vote typically on the abortion cases, whether to uphold or to strike down certain kinds of restrictions. A couple of years ago, or 3 years ago now, in 2016, there was a similar type of regulation out of Texas that the court struck down 5-3. This was after Justice Scalia passed, so there were eight justices there. But again, requiring physicians who perform abortions to have admitting privileges at a hospital, in the Louisiana case, within 30 miles. And the abortion providers say that would get rid of all but one provider in the state. It's unclear whether, however the court rules, whether that would mean a change in Roe v. Wade and Planned Parenthood versus Casey in the standards that courts apply. This is not a fetal heartbeat bill or other kind of broader restriction that states like Alabama and Georgia have passed in the last year. This is kind of the first small step. We'll see how the newly composed court, with Justice Kavanaugh and with Chief Justice Roberts being in the middle, how it will respond to an abortion regulation.
And Ilya, looking ahead, what other major cases are on your radar for this term?
There's a Second Amendment case for the first time in over a decade out of New York City, a regulation that prevented transporting your licensed, unloaded, locked firearms outside of city limits, even if you're going to a shooting competition or your second home, what have you. The court has not defined the scope of the Second Amendment outside the home, so it could start with that one. A case out of Montana that is possibly the last legal barrier to school choice programs. You get a tax credit if you donate to one of these scholarship organizations, and then that gives funds to students and their parents who can use it to all sorts of schools, including parochial religious ones. And rescinding DACA, the protections for people who were brought here illegally as children and have kept their noses clean. President Trump rescinded that move by President Obama. And the question is whether he can do that, whether he has a good enough reason for doing so. It really is a challenge regarding executive power, not so much the rights of immigrants writing on a blank slate.
Right, certainly one of those hot button issues, though, especially right now as the 2020 election looms closer. Ilya Shapiro, Ilya, thank you so much for your insight.
My pleasure. Take care.